be called upon to decide. This poses both Commerce Clause and Fifth Amendment problems. Now let's talk about the Commerce Clause first. The Supreme Court has been all over the map in determining what the extent of the Commerce Clause is. There have been expansive cases, there have been restrictive cases. And I think that it's very difficult to determine what trend the Court's taking on a Commerce Clause question. I think it largely depends upon how the majority of 5 or perhaps more feel the way it is. But there are several things that I think come into play here. In 1868, the Supreme Court held that insurance wasn't commerce. Now, whether or not that precedent will hold today is open to debate. But if that precedent is followed and not distinguished or overruled, that closes the argument. Because if insurance isn't commerce, then the Commerce Clause can't be used to create or regulate it. If the Supreme Court does distinguish or overrule the 1868 case, then the Obama bill has got another problem. And that is that the insurance exchanges that are established by Obamacare only have insurance pools that are within a state. The Republican alternative, which was rejected, allowed insurance pools to be multi-state or nationwide. But if the insurance pools don't cross state lines and the exchanges are set up within a state, then you don't have any commerce if insurance is commerce crossing a state line. And that argument is going to have to be answered. Now, the Commerce Clause has always been used to regulate economic activity. If you look at the arguments of the Constitutional Convention, the framers did not want to have the 13 states establishing tariff barriers to try to keep goods and services produced in other states out. And that's why interstate and foreign commerce was given to the new federal government and specifically the Congress to regulate. But failing to buy insurance is economic inactivity, meaning there isn't any economic activity, and it will require major judicial activism basically to turn around previous decisions 180 degrees, because the regulation has always been the economic activity rather than the economic inactivities. The argument that would be made against what I've just said is that no state must participate in Medicaid, which is the condition of having these insurance exchanges, and that would cure the problem. But practically that would be ineffective, because if a state pulls out of Medicaid, its citizens will continue to be taxed basically to provide Medicaid services to other states, and that is certainly not a winning platform for any state legislator or governor to run on. So I think that they painted themselves into a corner saying that the Commerce Clause actually authorizes what has been enacted into law in Obamacare. So if you look at the arguments that have been made immediately after the passage of the bill, all of a sudden, rather than the penalty for not buying insurance through the individual mandate being okay by the Commerce Clause, they're starting to call it a tax. Well, the penalty is not called a tax in the text of the bill. There are other provisions in the bill that are specifically stated imposing a tax, and I'll give 3 examples of it. One is the tax on Cadillac employer-sponsored health care plans. The other is the tax on tanning beds. And then there is a passive transaction tax if you're over a certain amount of income on sales and purchases that trigger a capital gains tax. Every one of those in the Obamacare bill states specifically that the bill imposes a tax on these types of transactions. There never is anything stated in that text of the bill that says that the penalty for not buying insurance under the individual mandate is a tax. And I guess I can say if it quacks like a tax, if it waddles like a tax, if it acts like a tax, it's a tax whether it's called a tax or not called a tax. And this one is not called a tax. Now finally, I think that the arguments that will be initially made by the supporters of Obamacare in court are that nobody has standing to be able to mount a constitutional challenge. And if this forum were held 4 years ago, I would say they'd probably win on that issue. However, in the case of Massachusetts versus EPA, which interpreted the Clean Air Act as allowing the Environmental Protection Administration to regulate greenhouse gas emissions, there specifically they stated that the state of Massachusetts had standing to file this lawsuit and to win it in the Supreme Court in order to protect its citizens. So I think the argument of standing is a bad argument if you don't talk about Massachusetts versus EPA. But if the Supreme Court ever says that Massachusetts versus EPA did not confer standing, then Massachusetts versus EPA ends up falling as well. Now, in conclusion, in my opinion, judicial action is the only way to stop Obamacare, at least until January 20th, 2013. And the reason for that is that political action will be impossible, even if the Republicans win control of both houses of Congress in the November election, because any major change to Obamacare, which is an entitlement program and in most cases not subject to annual appropriations by the Congress, will be vetoed by President Obama. So we have to put all of our eggs in the judicial basket. And just to repeat, this is not a slam dunk that it's going to get thrown out of court. I think there are enough legitimate judicial questions that have got to be litigated and resolved. And my bet is that one of these arguments will end up getting 5 votes in the Supreme Court. Thank you.
Thank you, Congressman Sensenbrenner. Randy Barnett.
Thank you, Tom, for inviting me, and thank you, Congressman, for those remarks, which I largely agree with, almost entirely agree with. When we talk about whether something is constitutional or not constitutional, there are 3 different senses of constitutional that people mean when they say this, and it's important to keep these senses separate so that we don't talk past each other. The first sense is whether something, the first sense depends on what the Constitution says and what the Constitution means. The second is what the Supreme Court has said and what the Supreme Court has meant, and the third sense is, can you count to 5 votes? These are not the same things. If you're going to evaluate the constitutionality of the health insurance reform measure that we're calling Obamacare, under what the original Constitution says, this would not be a difficult case. Both the individual health insurance mandate and the various requirements that are imposed on states would be unconstitutional under the original Constitution, even as amended, the original meaning of the Constitution as amended. And in fact, I doubt there would be any constitutional scholars who would disagree with that claim. But that's not the realm in which we are debating the constitutionality of this measure. We're debating the constitutionality of this measure in the second and the third realms, which is what has the Supreme Court said about the Constitution and what the powers of Congress are, and what is our prediction about counting to 5 votes in the Supreme Court about a lawsuit. So let me just talk a little bit about what the Supreme Court has said. Since the New Deal, the Supreme Court has interpreted the Constitution as radically expanding the powers of Congress, particularly over the national economy. In a series of cases decided in the New Deal, it essentially held that Congress could regulate even activity that was not interstate commerce in pursuit of its power over interstate commerce, so long as that activity was economic in nature and had a substantial effect upon interstate commerce. And this allowed Congress to regulate all kinds of economic activities that were wholly intrastate and not commerce itself. And one of the things you might be asking yourself is, well, what is commerce?